Morning.
Good morning, Your Honor.
Good morning. Can you guys hear me? Yes.
Yes.
Good morning. I'm Judge Tammy Long Hayward. This is the 11 a.m. calendar for civil hearings in Clayton County State Court, courtroom 304. And the first case that I have on the calendar for the 11 a.m. hearings is Alejandra Cano versus Christopher Gerard.
Yes, Mike. Sorry, I was going to say Michael Arndt here for the plaintiff, and our law school intern Barbie Minicata is also on the Zoom.
All right, welcome, Ms. Minicata.
Good morning,
Thank you, Your Honor.
Apologize. Morning, Your Honor. Ryan Ingram here for Mr. Mingo, the defendant.
All right, so now you all have had quite a bit of traffic with respect to what's been going on back and forth with discovery, some third-party discovery requests, and motions to for protective order, motions to quash, motions to compel. What's going on that we can't play well in the sandbox?
So I think it'll be simple for this morning that the two live motions to compel are plaintiffs' motion to compel and for sanctions against the defendant, and then defendant has a motion to compel phone records that will also be heard. The motion to quash is moot. Those depositions were noticed in June, and defense counsel agreed to not go forward with them. The basis of our objection was that discovery had long been closed, and the court has reopened discovery. So that matter is now moot, and we don't need to hear it. So I think it's just the two. And when Your Honor's ready, I can present the plaintiff's motion.
All right, Mr. Ingram, do you have anything on behalf of the defendant that needs to be heard before we get started with the plaintiff's motions?
No, Your Honor. I think all the motions are kind of tied together. I would say that we have a little bit of a disagreement about the motions to quash simply because the plaintiff has indicated they still don't want those depositions to occur, and we agreed to not take them given the court's order. We want to maintain the status quo so that Your Honor could hear the motions without anything changing. So we still would appreciate the court's guidance on discovery and those depositions, but I think sort of all this is tied together. So I would welcome Mr. Arndt to address the motions first.
And this is an automobile collision?
Yes, Your Honor.
Yes. It happened August 18th of 2021. Defendant Mingo, after consuming alcohol and marijuana, caused a single car collision. My client, Ms. Cano, was the passenger, and her arm has been amputated as a result of the collision. So for plaintiff's motion for sanctions, we're here because defendant failed to respond to interrogatories for more than a year. The interrogatories were served with the complaint on June 5th of 2023. Defendant's counsel drafted responses that were not verified. Those were served on August 21st of 2023. Plaintiff has repeatedly sought proper answers in the form of a good faith letter on November 2nd. And then there were several emails about the topic, specifically on February 9th, March 1st, March 15th, and March 19th. The basis for our motion is very simple. The statute requires the party it says the parties shall answer each interrogatory separately and fully under oath. That hasn't happened. And it hasn't happened, again, their responses drafted by counsel came in 11 months ago, and despite many, many opportunities, defendant refuses to verify the interrogatories.
Okay, one second, Mr. Arndt.
Sure.
Let's separate this. So I don't want to conflate what you're saying. So is the issue that they have not fully responded to each and every interrogatory that you propounded? Or is it that they did not verify their responses? Is it that we're dealing with both of those issues, or it's just that we're missing a verification such that they don't meet the requirement of having propounded that or responded under oath?
It is both, but the law states that if counsel just drafts responses, that's a complete failure to respond. And the authority for that is Gregory versus King Plumbing Inc. That's 127 Georgia App 512. That's a 1972 case that has been repeatedly cited to for that proposition. The quote is, "The plain and unambiguous terms of the Civil Practice Act require a party to answer personally his opponent's interrogatories under oath. Interrogatories are not pleadings and counsel cannot answer them." And that's been repeatedly stated throughout the law. So if your counsel just drafts something and you don't swear to it, it's not an improper one. It's a complete failure to respond that warrants striking the pleadings. Defendant's response is, you could have asked our client all of the interrogatories in the deposition. That has been addressed by the Court of Appeals. The case is Porter versus E Airlines Inc. That's 165 Georgia App 152, and it's at page 155, and that's a 1983 case. And the quote is, "Appellants further argue that the interrogatories were answered at a deposition.
Not the same.
Interrogatories served on a party must be answered separately and fully in writing under oath." And that's a Court of Appeals case affirming a sanction for a party refusing to verify their interrogatories.
Yeah, generally, when people go to depositions, they're using the interrogatories to either verify or box in the person that they're deposing. And so, yeah, I get that they're separate, and the requirement is that they be separate.
And that's right. And so defendant tried to supplement their interrogatories, still not verified, and counsel just went in and would try to cite to pages of the deposition. Many times this wasn't actually responsive to the interrogatory. But as you point out, the whole purpose is that you try to get them under oath to get their position. And then there's the potential for impeachment. There's the potential to confirm details in the deposition. It's just improper to refuse to do so. So I think the intent to disregard the obligation is very clear in this case. Like I said, it's not one where we rush to the court, that there were multiple communications, and instead of just verifying them, which would still, the court could still issue sanctions after a motion has been filed. But instead of doing that, we now have a brief, a response, a reply brief, a whole bunch more motions for the court, and they just can't do the basic thing that they were supposed to do in August of last year. So I think the intent is clear. And the last point of how we know that it's intentional is there was a second set of interrogatories that related only to our 9/11/68 offer. We send 3 short interrogatories after a 9/11/68 offer has been rejected, just to make sure that if we get an excess verdict and are trying to collect the attorney's fees under the statute, that there's no argument that it wasn't properly served, all that sort of stuff. So that was our second set of interrogatories, and they verified those. So they're aware of the obligation. They've been repeatedly reminded about their obligation of the first interrogatories. And I've never seen a case where a party just refuses to do so for more than a year.
Mr. Arndt, let me ask one more question. Is there a pending criminal case in this matter?
No, it's in pre-indictment. So we can't get a lot of the police's file as a result of it, but there's no actual case.
That's actually not the reason I asked, Mr. Ingram. Is the lack of a verification related to a Fifth Amendment, I guess, desire not to incriminate oneself? Can we flesh this out as to why we can't get a verification?
Well, Your Honor, first, I believe that the verification we execute, or my client executed, that Mr. Arndt referred to, refers to all.
The second set of interrogatories?
I believe that verification refers to all interrogatories in the case. That was certainly my intent as the lawyer for that to apply. And second, yes, Your Honor, there is a Fifth Amendment issue. There's an ongoing criminal prosecution that's still open.
Did
And
you
this-
let Mr. Arndt know that that was the issue with respect to the verifications that he was requesting?
I cannot sit here and tell you with certainty that I did. I know that we've asserted that Fifth Amendment privilege a number of times in the case, and I'd be happy to go look at our correspondences. I'd be shocked if I didn't. That's just not something I looked at this morning, so I certainly don't want to misrepresent to the court.
Well,
in fact,
as someone who practiced civil litigation, but prior to taking the bench, but who's had quite a bit of criminal experience since taking the bench, that's kind of the reason I ask these questions is sometimes there are two competing themes. And if there are criminal matters that are pending, I always look to what the constitutional rights are of the person who's going to be a defendant in that criminal matter and how that balances with the civil matter. We probably could have instituted a stay or done something similar to preserve the issues, but to kind of let the criminal play out if that was what the competing issue is. But you gotta kind of discuss those things, because Mr. Art, if he's not a criminal attorney, that's not going to be uppermost on his mind. He's thinking, I have a plaintiff who needs to have redress for what is a catastrophic injury.
Your Honor,
And Judge, can I just address those very briefly?
Sure, Mr. Arndt.
The defendant did not assert the Fifth Amendment in his answer, and in all the motions that are pending before the court on this issue, the Fifth Amendment isn't brought up once. So I think Your Honor is suggesting a reason that was never offered. And if I can share my screen on the
I'm
second
not trying to tell him how to respond. What I'm asking is if that was the case, because if it were the case, there's a different set of decisions that I need to look at versus if it wasn't. But if it was never mentioned, then Mr. Arndt has gone through a lot to secure a verification, which we could have simplified all of this. And so while me forcing you to do a verification might not be appropriate, sanctions might be.
And I can show you the verification for the second one. It very clearly states that it's for the second interrogatories, if that's okay.
Thank you. I was going to request that next.
Can you see my screen, Judge?
I can.
So here it is, defendant Christopher Gerard Domingo's responses to plaintiff's second interrogatories.
Yeah.
So
That's not an omnibus verification, Mr. Ingram.
yeah, you're correct, Your Honor. I stand corrected. That's my mistake. I just assumed. I apologize.
Yeah, I'm one of those people who is from the old school with civil. If we can be as open and direct as we can be during discovery, it helps the case come together a little bit better. If I can see that there's maybe some competing issues with respect to the defense, even if it's in a pre-indictment stage, Mr. Arndt, it doesn't erase Mr. Mingo's right to preserve his constitutional rights under the Fifth Amendment. However, a little bit of candor would have kind of cut out all of this back and forth, and we could have structured it a little bit differently so that you're not continuing to seek something that you weren't going to get at this stage in the proceedings.
Your
Because I
Honor,
don't think I can force, verification is required, but I don't think I can force under the OCGA him to verify interrogatories that might, under the United States Constitution, jeopardize his right to a defense in the criminal case.
And to that point, it is his personal right, and he can absolutely assert it. He just hasn't. Like I said, that he didn't put that in the discovery responses. He didn't put that in any of the motions. He didn't put that in his pleadings. So if his answer is, I'm refusing to do so under my Fifth Amendment privileges, you're right, we're stuck with that. But that's not what's happened, and this isn't coming up for the first time today. That this is, like I said, something that we've talked about an awful lot in following depositions and emails and motions, and not once has Mr. Mingo suggested that that was the reason. There's never been a reason suggested. They've just said, hey, we don't have to do that, and that's just contrary to the law.
Is the criminal case pending in my county?
It's in DeKalb. Like I said, it's pre-indictment, but it would be DeKalb.
And Your Honor, if I may, first, you are correct. After I took criminal law in law school, I said I never want to touch anything criminal again, and it's not in the forefront of my mind. I'll acknowledge to the court, I don't know anything about criminal law. I will also tell the court that I was not aware of Mr. Mingo's representation by a criminal defense lawyer until just shortly before his deposition. And you know, my job is to represent Mr. Mingo, and so that's what I'm here to do. But I also want to be clear with the court about the facts as I know them.
right.
And that is when I learned about it.
Okay. Go ahead, I'm sorry.
The other thing that I just wanted to say, Your Honor, is, you know, this is an awkward position for me personally, simply because the way I practice law and civil litigation is to try to avoid motions in situations like this, if at all possible. I was taught litigation is supposed to be face-up poker. We all have the same information, and we let the fact finder make a decision, and that's the way we operate. I don't think Mr. Arnn is suggesting that we just didn't respond on behalf of Mr. Mingo. We did. We asked Mr. Mingo to provide us with information. He provided some information, and we've provided everything that we have received from our client that's responsive to the discovery requests to the other side. We're not withholding anything, and we've informed Mr. Arnn of that, anything that I personally as the lawyer am in possession of. I would also say that, you know, we did inform opposing counsel multiple times, like I said, that we're not withholding anything. I do believe the Fifth Amendment has been discussed in the case, but again, not until around the time of Mr. Mingo's deposition in March. And at the time that I learned that it needed to be asserted, it was asserted in that deposition. I would also say, Your Honor, that there's some more information that I think the court might benefit from being aware of when evaluating the pending motions. You know, the plaintiffs asserted this is a simple case, and they're ready to try the case. We disagree because we haven't been able to conduct multiple depositions of some fact witnesses and impact witnesses. But the plaintiff's assertion that this is a simple case seems to be at odds with the plaintiff's claim that they need more information from Mr. Mingo. And that's specifically at odds with what we learned during the plaintiff's deposition, which is that the plaintiff and the defendant maintain a romantic relationship today. And, you know, that's something that I learned in the plaintiff's deposition, that, you know, the plaintiff and defendant had dinner the week before the plaintiff's deposition. Ms. Cano also testified that
So do her claims of damages in a car accident go away because they are romantically involved? I'm kind of unclear as to what statute that is.
No, Your Honor. The point, though, is that, you know, to the extent the plaintiffs claim that they need information from Mr. Mingo, we know as a factual matter they talk all the time, at least according to the plaintiff and the defendant.
But that's not how this goes. I can talk to my neighbor over the fence, but if he sues me about a tree that's about to fall on his property, our attorneys are going to talk. Even though we're still talking, I can still lend him a cup of sugar. Our attorneys are going to talk, and they're going to go through the formal process of figuring it out. So the fact that they're still related romantically, neither here nor there. What we need to do is follow the Civil Practice Act and gain the information necessary to litigate this case through the rules and procedures under the Civil Practice Act. And so, with that being said, we need to respond to interrogatories when they're propounded. I mean, if they're still good together, that's fine, but seems like the plaintiff doesn't really have any way of kind of pushing the defendant to come in and sign a verification or meet with you to determine what's necessary to go forward in the case. And so if that's the issue, then we have you know, the romantic relationship is not having any bearing on the civil litigation. The second thing is, my understanding is that there were motions to quash for third-party individual, entities. But I granted the additional time, thinking that that would take care of that issue. But if there are still reasons that those parties can't provide information, then I need to know what those are if we're going to fully resolve all of the discovery issues.
And Judge, I can short circuit that one. So Mr. Ingram was seeking 2 depositions. It was Arsheen and Miss Gruwall. And when discovery has been extended, most of our objection has gone away. We have told Mr. Ingram we don't intend to call those people at trial, and we can make that a stipulation if that matters. But we don't have a basis to oppose their depositions anymore. So like I said, we don't think it's necessary, but we don't have a basis for a protective order. So that one is off the table.
It's their dime. So it's even if you don't intend to call them, the purpose of discovery is to what could lead to information that could be produced at trial, not as necessarily going to be produced. So they have a thought about what these 2 individuals could add to their litigation, then I'm fine with them. So we'll go ahead and get a schedule going so we can get them deposed, even if I have to extend discovery further out, so we can make sure that once we get back to the stance of being ready for trial, we don't have any outstanding issues. So that's taken care of, Mr. Ingram. Is there anyone else?
Yes, Your Honor, the defendant's motion for production of records from AT&T, there would be the cell phone usage records of the plaintiff from the date of the origination of their relationship until the present time. And the reason for that request, Your Honor, is that the plaintiff has asserted a claim for punitive damages. And to the extent the plaintiff intends to assert to a jury that Mr. Mingo should be punished, any change or lack thereof in their relationship is potentially relevant for the jury to consider. When the plaintiff says, I'm upset with this guy and he should be punished under the law, if their relationship continued in the same manner that it was prior to the accident, that's something the jury should have the benefit of knowing when evaluating that claim. And so that's the reason for the request, Your Honor. We've offered as a compromise to make the same request.
Whose records, your client's records? Whose records are we asking?
The plaintiff, Your Honor.
Okay.
And we've offered as a compromise to request the same records of both the individuals out of simple fairness, Your Honor. But if the plaintiff is claiming that the jury should punish Mr. Mingo as she is, then the fact that her relationship has either not changed or changed would be potentially relevant. If she decided we don't need to see each other anymore and I don't want anything to do with you, the jury should know that. But similarly, if Ms. Cano decided, you know what, despite the accident and what occurred, our relationship should continue or even become more frequent, then the jury should know that. Certainly up and through the time of trial that they're asking a jury to punish Mr. Mingo. And so that's the reason this is the best possible evidence to show the nature and extent and frequency of the communications between these 2 individuals from the time of their relationship as it existed at that time, which Ms. Cano testified to, and then as it existed afterwards. As an example, we know.
Would this just be contact information or content information? Are we talking about how many times they've called each other or when was the last call versus any text messages, content, that kind of, not that I know whether they keep it. I think they keep everything, but hey, that's just me.
I agree, Your Honor. I agree. I assume everything is kept, but no, Your Honor, we're not seeking content, just the nature or excuse me, the frequency of the contact, whether calls and duration of calls and the time and extent of text messages between the 2. And it would be potentially relevant to see if that communication stopped for a time period and then restarted, and when in relation to the plaintiff's filing of this lawsuit that occurred. And certainly if it's less, then that would tend to be consistent with plaintiff's claims that Mr. Mingo should be punished. If the frequency of contact between them is more after the filing of the lawsuit or after the incident, then the jury should know that they talk even more after the incident. That's
Is
potentially.
is there some case law that supports what you say? I get it from the standpoint of how to proceed from a trial procedure standpoint, but from the standpoint of helping a judge determine how relevant that information would be, is there case law where, you know, a plaintiff and defendant have remained romantically linked and during the course of litigation?
Your Honor, I haven't found any case law specifically on that point, but I would say as the court is aware, and as you mentioned earlier, discovery is broad, and if it's not relevant, we can exclude it at trial. I'm not asserting that all the information we may gain from these requests is relevant. I don't know until I see it, but I just think that the jury should have the opportunity, if it is relevant, for us to present that information to the jury.
All right,
And
Mr.
that's
Arndt?
just basic
Oh, I'm
discovery. I apologize, Your Honor.
Yeah, I got you. Mr. Arndt?
So a couple things. One, the basis for our punitive damages claim is Mr. Mingo's decision to operate a vehicle at 4 times the speed limit after having marijuana and alcohol. So as specifically as possible, and this is quoting from the complaint, defendant was operating his vehicle in a reckless, negligent, malicious, willful, and wanton manner. So several of those are the predicate for punitive damages, but it's the operation of the vehicle that is the punitive claim. Whether or not defendant and plaintiff had romantic relations, they were dating exclusively, not exclusively before, they've had dinner since, is completely irrelevant to plaintiff's claim for punitive damages. The punishable behavior is the way that he operated the car, and how many times they've talked in the 2.5 years of records after the collision that defendant is seeking is totally irrelevant. So that's the first thing, is I think they misunderstand what the punitive claim is. It wouldn't be evidence for us if they had never talked again to say, see, plaintiff is red hot angry at defendant, and that's why you should issue punitive damages. That wouldn't be an argument for punitive damages. Likewise, the opposite of saying they have talked, they have gone to dinner after going through this traumatic event together. That's not evidence either as to whether punitive damages should be awarded. Sorry,
I would assume that that's information that's going to come up at trial. There's nothing that would prevent either one of them from answering a question about whatever the state of their relationship is.
Potentially as background, but he was making it sound like it was a substantive inquiry as the punitives, and I was just pointing it out. But you asked for law, and in our briefing, we provided federal authority.
Okay. Yeah, I'm open to anything at this point, because I'm pretty sure that if there was a pinpoint site or a case that had it, I'd probably have it by now, but I just...
So yeah, the quote, and this is from the Southern District, where they found requesting multiple years of phone records, quote, can easily cut very personal, which is overbroad and unacceptably annoying. The court thus grants plaintiff's motion to quash on that score. And that's Martinez versus Rye Cars Construction, LLC. And it's in the brief, but the site is 2010 Westlaw 411-7668, and it's at page 2. Another one very similar, seeking several years of phone records, and the quote was, clearly is overly broad and not limited to relevant and discoverable information. So I can't imagine a case where we would ask the court to compel the defendant to say, every person that you've communicated with on the phone, with a phone call or text message, even if we had you're using your phone a lot when you're driving type claim where it could be relevant as to what you're doing with your phone.
That was what my question was pointed at, because generally those requests are overbroad unless they're they're really kind of confined to immediately before and immediately after the incident.
And to that point, that was our proposed compromise where we said 3 years of absolutely all calls, all texts, all data usage is way overbroad. We'll give you the day of if you think that's relevant for something. We don't think it is. Again, she was a passenger. It wouldn't matter if she was on the phone. But we did that as a proposed compromise, and they didn't engage with that they want the whole shooting match. So again, 7.5 months before the crash and 2.5 years after. I've never heard of such a thing. And their stated reason seems to misunderstand the punitive claim that we're making. The punitive claim is your decision to drive at 4 times the speed limit is a conscious disregard of the safety of others. It has nothing to do with who you talked on the phone with.
Is there any other part of the punitive? Is that the sole claim under punitives, or is there anything else that fleshes it out anymore?
The potential substance abuse before driving is related, but no, it's exclusively how he was operating the vehicle. Yeah.
All right, Mr. Ingram.
Your Honor, I would just say that the court's well aware of the pattern jury charges that the court gives on punitive damages. Punitive damages are authorized to punish or deter future conduct. And in this case, I agree, it is a rare case where a request for records this broad may be relevant, but here it's reasonably calculated that there may be discoverable and relevant information in those records. I would say in terms of the plaintiff's concerns, we'd be happy to not receive any records other than records of communications between the plaintiff and defendant. I'm not interested in anybody else's communications or the plaintiff's communications with anybody else. But again, to the extent the plaintiff is claiming that the jury should punish or deter future conduct, it's potentially relevant for the jury to understand the nature of their ongoing relationship, whether it is increased or decreased in frequency. And as an example, Your Honor, I learned during Mr. Mingo's deposition, after plaintiff's deposition, she testified that she had taken Mr. Mingo to a dental appointment the day before her deposition. And about 30 minutes after that testimony on the record, we received a communication from Mr. Mingo that because of dental work he had recently received, he wouldn't be able to appear that day for his deposition. About a month later, we finally had Mr. Mingo's deposition, and we learned in that deposition that she did in fact pick him up and drive him home from that deposition or that dental appointment. That puts both of these parties in a car together. That's potentially relevant information. And again, that's only borne out by the nature of the relationship and the ongoing relationship. And again, it may not be relevant, Your Honor. We may not need to present that information at trial, but if the plaintiff continues to associate and drive or ride with the plaintiff, or excuse me, with Mr. Mingo, the jury should have the benefit of that knowledge when deciding whether the plaintiff is correct in saying that Mr. Mingo's conduct should be punished and future conduct similar to what happened on the date of incident should be deterred by these punitive damage claims.
Okay, if the punishment we want to deter is not his association with the plaintiff, but the punishment, the conduct of driving too fast and drinking and partaking in illegal substances and driving, if that's the conduct that we want to deter by punitive damages, nothing in the AT&T records is going to make that true or not true. I mean, if you want to deter them from having a relationship, or that's an entirely different track. And whether he gets punished or not punished, I think that the argument that I'm seeing is, hey, jurors, give her less money because she's still associated with the person who drove and took her arm, as opposed to he's, the punishment, the punitives are for the way he drove and what he, consumed while he was driving or before he drove. And so that's a different argument. I don't know that AT&T records are going to lead to anything that helps you to defend against the punitive claims with respect to how he drove and what he consumed before driving. And so with respect to that, I can tell you now that the AT&T records are not going to have to be produced. We'll go
Your Honor,
ahead and,
I apologize. I'm sorry, Your Honor, I was just gonna say
it's
that.
a fishing expedition, Mr. Ingram. And I mean, mind you, I've done my fair share of of civil defense, but it's an argument if you want to make it, if it comes up in trial and you want to make that argument, hey, they're still seeing each other, they're still talking to each other. Those are questions that can be elucidated at trial. But the issue that we have here is whether the AT&T records are going to lead to anything that could be relevant. And in the broad use of my powers of discretion over these discovery issues, I'm not seeing it. And so the argument can still be made if it comes up in trial, but I don't know that we need to do 3.5 years of AT&T phone records to verify that they still like each other. And in another context, I hate to say this, but it tracks with what I know about, and I'm not saying this is an abusive relationship, but in abusive relationships, there can be all kinds of injuries and damage, and they still see each other. And so I don't know that it changes the level of damage or the type of damage or how the damage was done, just to know that they're still together. What we're trying to, what punitives would deter in this case is Mr. Mingo allegedly, all this is alleged because we haven't gone to trial yet, nothing's been determined, but him essentially imbibing in illegal substances and overuse of alcohol and driving in a way that could hurt anyone, not just this particular person who was riding with him. So
Thank you, Your Honor.
I just think that it's overbroad, and I don't know that it will lead to anything that will assist you with respect to that based on the arguments you've made in writing and today. Now, I think we're back on track. I think that Mr. Ingram, I'm going to give you 10 days to get with Mr. Mingo's criminal attorney, and you're either going to assert the Fifth Amendment in writing and explain what you can and cannot do based upon that Fifth Amendment right against self-incrimination with respect to the civil discovery that has been propounded, or you're going to verify the first set of interrogatories.
Yes,
And Judge, can I just clarify that? Two things. One, can we have the objections removed? As an example, our interrogatory number 5 just said, in the 24 hours before you drove, tell us if you were on medication, any illegal or legal substances that you took. And their objection was that this is protected by HIPAA, which is obviously wrong.
Yeah, that's
so
not,
again,
because if I did a search warrant, that wouldn't be protected by HIPAA. And if it comes up in the criminal case, while it may be protected until the criminal case goes to trial, it's gonna be public at some point. So HIPAA's not gonna protect what his blood alcohol level or level of intoxication from any substance is. So no, yeah, let's update those. But if the response has to be that a pending criminal case and Fifth Amendment, then fine, but make sure that the record is clear and correct.
sure.
Yes, Your Honor.
And that's all I was going for. So we'll either get a Fifth Amendment, I can't answer because of the Fifth, or we'll get a clean answer.
Yes,
Within
and if
10
you
days.
get-
Gotcha.
Yes, and if you get a clean answer and there's no Fifth Amendment, say the case goes away between now and then, I don't know, I'm not a district attorney and they have the right to prosecute, but then you'll have 10 days to either give clear answers that this is Fifth Amendment protection, or you're going to verify the first set of interrogatories.
Your
Now,
Honor, if I may, to be clear, as to objections, if there are other objections that are appropriate as to breadth and scope and things like that.
yeah, make them.
Okay, thank you, Your
Yeah,
Honor.
but just be clear about it. I don't know that HIPAA, because we can get around HIPAA. I don't know that is not a end all and be all in a discovery issue. But if there are other objections that
need to be asserted, please make sure that you assert them. But if the main reason we can't get a verification is because of the Fifth Amendment, then make sure that's asserted and Mr. Arndt is not left in the dark as to why this case is not moving forward as quickly as it could. Now, with respect to the Art Sheen and Gruel, if you want to depose them, notice it within 45 days of today's hearing. If you don't want to do it, then fine. Then y'all go ahead and knock those out. And if at any point we get to a situation where the case is stalled because there's a criminal matter pending, and y'all want to, let's stop the case here at this point. Let's see what happens with and it may benefit you too, Mr. Arndt, because a lot of times people will wait to see. And if it's a conviction, it helps plaintiffs. If it's a acquittal, it helps the defendant. So y'all both may benefit from something like that. But if that is the case, let's go ahead and have a little telephone hearing or a little Zoom conference, which is not necessarily a hearing, but let's talk about it. Let's see how we can best move this case forward without having to go back and forth with a lot of motions. Okay.
Sure, Judge, and I hate to do this, but just one more thing that a problem that we have in this case is what I think is going to happen because of what they've produced is they will say things like, and this is a quote, "We have already produced all non-objectionable responsive information without indicating what is being withheld for that non-objectionable. Tell us specifically what is objectionable." So if they say, you asked for 5 years and we only think 3 years are discoverable, it's very clear that we're withholding 2. That's fine, and we can discuss that, and if we need to bring it up, that's fine. But when you say object to every single discovery request as they have, and then say, we've given you all the non-objectionable stuff, we have no idea where we are, and we have no idea whether knowing if we have the whole universe, whether they're withholding a little bit, a lot of stuff. If their answers don't make it clear, it's impossible to know where we are. So I understand that they're not going to give straight answers to everything without any objections. My only request is that it has to be very clear what is being withheld so we know if we even need to argue about something or not. And without that, we just have no idea of where we are.
Your Honor, we agree completely. And as I said, we're not withholding anything. And I believe very strongly as a lawyer, we have an obligation to make sure the other side is aware if we are. I'm not a hide the ball person. I think that's totally inappropriate. And we will make clear if there is something being withheld. I don't expect that to be the case because as I've explained multiple times before today, we are not withholding any information pursuant to our objections. We simply have an obligation to defend Mr. Mingo, and we have done that by objecting when appropriate.
Okay. Well, I trust that you both know the Civil Practice Act, and I want to make sure that the responses are clear and are complete as complete as they can be, because otherwise we're just going to spin our wheels. Mr. Ingram, I can't tell you what to do on behalf of your client, but I do. The suggestion has been made that you speak with his criminal attorney because, as you've pointed out, that's not your bailiwick. So you may want to get direction because there may be some things that, can be produced based on what's already out there. The police report is already going to be out there. Any information that the investigators have already given in maybe a preliminary hearing or something like that is already out there. So there may be certain things that may be produced by your client or other parties that you all can say, well, this is already out there. But as for what my client responds, and then say your objections. So I trust that y'all are going to be able to get that done, and we'll move forward. So this is what my order is going to look like. With respect to the plaintiff's motions to compel, the motion to compel for the phone records is sorry. Okay, so the motion to compel the AT&T phone records, that's denied. The motion to compel for the verifications of the interrogatories, that's granted to the extent that the Fifth Amendment right against self-incrimination will be asserted where appropriate, or a verification will be given if the Fifth Amendment right against self-incrimination is not asserted within 10 days of today's date.
And Judge, just the, as for the depositions, in hopes of avoiding involving the court again, our concern is at Ms. Cano's deposition, there was a lot of talk about her sexual history. She's a woman in her 20s. I don't think that's relevant to anything. We're not claiming that she can't have sex or anything like that.
I hope not.
Yeah, so they asked if she had sex on Christmas, whether she had sex in her family's bed, whether she received any, she had to give anything in exchange for all the money. So I don't want any of this coming up with the witnesses. And if we can get a stipulation on the record, I promise we won't have to come back to court, but we really don't want to go there. And we've tried talking about it. We think it's completely out of bounds and it should be not brought up in the deposition.
She lost an arm, not her libido. What, I mean,
Correct.
is
Your
there a
Honor, this is
necessity for?
Your Honor, I have tried to not, these cases are about the parties, not the lawyers, and I have been repeatedly attacked. I have been repeatedly attacked. It is untrue what Mr. Arndt just said. The word sex was not in my questions, but the nature of their relationship before and after the incident is potentially relevant. And I did ask if they maintained a physical relationship before the incident and after the incident. This assertion that I asked her specifically where they had sex or anything like that, completely false, Your Honor. And I object to the personal attacks against me.
So I want to be real clear on that. So hang on one second, Judge, and I hate to interrupt. The question of did you share a bed with him and are you still physical? Those were exclusively about sex. And the fact that you didn't use the word sex, the court reporter afterwards commented about how inappropriate it was for a middle-aged man to be asking a 20-year-old about her sex when it has nothing to do with the case. It's not like we created it, and we've brought it up multiple times, and all we're asking for is a stipulation that is out of bounds and should not come up to try to harass and intimidate a 20-year-old in a deposition by intimidating her friends and talking to her friends about her sex life. Completely out of bounds, and all we're asking for is the stipulation. The deposition is in the record where those questions were asked. Why were you initially attracted to him? All of those things, nothing to do with anything, and we need to put a stop to it. Was the only reason we brought it up.
It's entirely inappropriate, the innuendo that's being thrown at me, Your Honor. I'm happy to review the entire transcript. They are appropriate questions necessary for me to ask. And Your Honor, let's be honest, this is a unique case. I have never defended someone where they have an ongoing relationship with the person they've sued. And I, as the lawyer, am having a difficult time getting information to respond to discovery while there's communication going on between the parties. It's a very strange situation, Your Honor, and I'm doing the best I can to represent Mr. Mingo.
I got it, Mr. Ingram, but Mr. Ingram, you've not knowingly represented anyone who had an ongoing relationship. A lot of people do, and they don't tell you. Number one. Number two, I think that this is more of a normal case than you're letting it out to be. What we're dealing with here is a catastrophic injury with respect to a one-car accident, collision. There's nothing more normal than car accident cases. I mean, that's the bread and butter of civil litigation. And so from that standpoint, whether she's having sex with somebody, who she's having sex with, if it's not, I mean, if they weren't having sex in the car at the time that the incident happened, I'm not sure that it's relevant, because we've already discussed the fact that they have a known romantic relationship. And so now that you know it, you can go ahead and assume they're doing everything under the sun and let that be it and work from that. But Mr. Mingo is as much involved in this case as is the plaintiff. And I'm not sure why her sexuality is any more necessary to review than his. Mr. Mingo hasn't, I believe, been deposed. Is that correct?
He has, Your Honor.
He has?
Yes, Your Honor.
Okay, and did we go into whether he was having sex or who he was having sex with?
Your Honor, similar to Ms. Kano, nobody asked them about sex.
Or, okay, a physical relationship?
I frankly, I wasn't there, so I'm not sure what was asked of him other than generally about the car accident.
Okay, well, I just think that strains the bounds of what is relative. And yeah. Unless he called you 12:30. Yeah, that strains the bounds of what is relative in this case. I mean, relevant in this case. And so let's just, if y'all have to come back to me and we have to have an in-camera frank discussion about what's necessary to talk about. But with respect to a 20-year-old taking a deposition probably for the first time, those types of questions can be somewhat intimidating. And I don't know that they're necessary to lead to information that's going to be presented to a court and a jury. I just think we have to be mindful of those things. We haven't, there was no attempt to find out if Mr. Mingo was still sleeping with the plaintiff. I mean, so if the reverse is not necessary, then I don't know that that's necessary. I don't know that it helps in any way to move this case forward. So let's just, I don't know who Art Sheen is, who's Miss Gruhl, who are these individuals? Let's get into that before y'all have to call me to certify a question or something.
Your Honor, these are simply Ms. Kano's friends who she said she associates with more than anyone else. And we anticipate they're going to be able to tell us about the impact on her life of this accident.
Okay, well, then we should be asking about how she gets around with an arm missing as a 20-year-old, as opposed to, whether she and Mr. Mingo are still doing the tango, horizontal or lateral.
Your Honor, there's never been an intention to ask them about that.
Okay, all right. So let's go ahead and get those depositions set up within 45 days. And then if there's anything further that needs to happen in this case, you all can email Miss Powell and she can put it before the court, okay?
Thank you, Your Honor. Yes, ma'am.
All right.
Thank you, Judge.
So
I appreciate the time.
thank you very much. Miss Minikata, turn your camera on for me. You still there?
There we go. You're on mute.
Oh, there we go. Hi.
Just
Thank you for letting me join and listen in.
It is my pleasure. I don't see many young law students. By the time they get to me, everybody's been practicing for a while. So I wish you well
Thank you.
in law school. I hope that you have enjoyed your experience in this hearing and interning. And all I say is be open to all the possibilities that this being an attorney allows you, because it is probably one of the most open fields that you can get into.
Yes, ma'am. Thank you.
Right. Take care.
Bye.
Thank you, Judge.
All right. Thank y'all.
Thank you very much, Your Honor.
Okay. All right. So the next case is, thank you for your patience if you've been here waiting on this case. So it's case 2020CV01192. This is the case where Minnie Harris is suing Jarman Brown, a deputy with the sheriff's office, and the sheriff's office in this case. We've had some developments with respect to appellate law that came down and clarified some issues in the case. But please tell me who's here on behalf of whom.
Good morning, Your Honor. My name is Chandler Emmons. I'm here on behalf of Jarman Brown.
Okay, Ms. Emmons. And Ms. Ingram.
Yes, good morning, Judge. I am here on behalf of defendant Victor Hill or Levon Allen. as it's been substituted.
All right. All right, so the substitution has been made in my mind, but I don't think we've gotten the order on that, but we'll go ahead and discuss that in a moment. Have you filed that for me, Mr. Ingram?
Let me check. I
Okay.
think plaintiff's counsel was going to file the order because it was their
Oh,
motion
okay.
to revive. And so last time I spoke to them, which was a couple of weeks ago, they were gonna file that order.
All right, Ms. Emmons, have you all been able to file that order
Which order?
for substitution of Levon Allen as the in the official capacity?
Plaintiff's
It's
counsel is
been
actually not on,
filed.
Your Honor. It's the two
Sorry?
defendants. Plaintiff's counsel is not on this Zoom.
Oh, the other defendant.
Yes.
Where are they?
Plaintiff isn't here.
Yeah,
Yeah.
plaintiff isn't here.
Oh, okay. Oh, all right, yeah.
And I do believe that you entered the order
I
substituting.
did.
Allen.
Okay, I just want to make
Mhm.
sure. So is plaintiff's counsel not coming?
I don't know.
I haven't heard from him.
Who's count? That's Jack Hitchcock, right?
No, Jack Hancock is from my firm.
Hancock, I'm sorry.
It's Dwayne Brown.
Dwayne Brown.
That's the law office of Dwayne Brown.
Okay, we have any clue why Mr. Brown's not here? Anybody heard from him?
No, I haven't heard from him.
So my fear, only because we had this issue in a previous hearing, is that there were issues with, I guess, e-filing. There have been some issues with notice under the e-file, but generally, I think we've emailed. Ms. Powell, have you heard from Mr. Brown's office?
No, ma'am. I did not hear from him about the proposed order that we asked him to send either.
Okay. So is there anything pending? I'm gonna just state that we've sent out notice. You all are here and you received notice. So is there anything pending that we need to discuss with respect to, I'm ready to go forward on the motion for summary judgment. I generally don't like to go forward without the other side because I don't do ex parte. But we did give them notice and their presence is waived if they haven't shown. And I've asked this, if no one has, Ms. Val, there's no leave of absence or anything for Mr. Brown? Anybody
Your
aware of one?
Yes, Your Honor. I believe he filed a leave of absence for, I think it would begin tomorrow, the 18th.
Okay. All right. So is there any objection to moving forward with the hearing
No,
in
no.
light of, okay, so Mr. Brown, Dwayne Brown has received the same notice as the other parties in this case. He's counsel for the plaintiff. The motion that is pending is a summary judgment motion filed by the defendant, Mr. Brown in this case. Is that correct?
Yes, and I do believe the sheriff is also on the motion.
Okay.
That is correct. They were represented by the same counsel at one point, and then we switched out.
Okay, and attorney Dwayne Brown, is that correct?
Yes.
Yes.
Is not here for some reason, even though his leave of absence does not appear to start until tomorrow, July 18th of 2024. The court does recognize he has a leave-in, but it doesn't start until tomorrow. All right, so I will hear the motion to dismiss, motion for summary judgment.
Sure. Jade, are you okay with me starting?
Yes, please go ahead.
Okay, so Your Honor, this case arises out of a motor vehicle accident involving Mr. Brown when he was a sheriff's deputy with former Victor Hill. Plaintiffs allege that the collision was directly caused by and due to Deputy Brown's negligent and tortious operation and control of his vehicle. Based on the foregoing, they bring this lawsuit asserting claims of negligence against the sheriff and defendant Brown. As for Deputy Brown, plaintiffs have asserted state law claims of negligence and negligence per se. Deputy Brown previously moved to dismiss plaintiff's claims, arguing that the claims against him are barred by OCGA 3692(3)(a), which prohibits claims against government employees driving government-owned vehicles in the performance of their official duties. In this court's order on defendant's motion, the court held that at the motion to dismiss stage, the individual capacity claims against Deputy Brown could not be dismissed because plaintiff might show that he was operating the vehicle in performance of duties that are outside of his official duties. Now, after discovery, there is affirmative evidence in the record that Deputy Brown was operating the motor vehicle on the performance of his official duties, and he is entitled to immunity pursuant to OCGA 3692(3)(a). Before the court is Deputy Brown's motion for summary judgment filed back in June of last year. The parties agreed to extend plaintiff's deadline to respond pending the Supreme Court's ruling in Cullington versus Clayton County, which was issued on January 17, 2024. And to date, plaintiff has not filed a response to our motion for summary judgment.
Okay. Have you all heard from plaintiff? Has there been any, I'm not even talking about settlement talks. Has there been any discourse between the parties?
We have talked settlement talks, but nothing substantive about this matter regarding where it is procedurally.
I was copied in an email chain where he acknowledged Miss Ingram being substituted as counsel for the sheriff. I haven't really heard much since,
Okay.
but that was fairly recently.
All right, and so Mr. Brown has always been on this case. He hasn't changed, moved, he's always been plaintiff's counsel.
That's correct.
All right, and he didn't file a motion to respond to the summary judgment motion.
No.
And okay, when did you file your motion for summary judgment again? I'm sorry.
June 2023.
Been more than enough time. And those issues would not have been impacted by the issue that we were waiting for from the Court of Appeals.
No, the issue in the Cullington case was the anti-litem notice.
Yeah, I just want to get it on the record. Okay, so what's the affirmative evidence that the then Deputy Brown was acting in performance of his duties at the time of the accident?
Well, the only evidence in the record is Deputy Brown's affidavit saying that he was doing so, which I have attached to my motion for summary judgment, but I can also pull it up.
Okay, no problem. All right, that's all I have. Miss Ingram, did you have anything else pursuant to the motion for summary judgment or anything else? Is there anything else pending?
Just the motion for summary judgment on Sheriff Hill's on his claims against Sheriff Hill in his individual capacity. It's basically the same as what Ms. Emmons was stating. There is no evidence for imputed liability, negligent entrustment, or failure to train. Of course, discovery is closed, and there has been nothing in the record that supports any of those claims. And so the sheriff would also be entitled to his official immunity in that capacity.
All right. All right. So based on the information that you have and the information that we have in writing, then we'll go ahead and issue an order in this case. Generally, when there's no response to a motion for summary judgment, as long as the motion is sufficient, then the moving party prevails. But I will make sure that we document that we had a hearing pursuant to this being a motion for summary judgment. Y'all get a hearing if you ask. And then also that the defense, the plaintiffs were given notice, the same as everyone else and did not appear and had not responded to the pending motion. Okay, anything else at this time?
No, that's it, Your Honor.
All
Thank
right,
you,
and thank
Mayor.
y'all, and thank you for your patience and waiting through the previous argument.
Thank you, Judge.
Thank you.
All right, y'all take care. Tell Mr. Hancock it's been a long time no see, but hello.
I will tell him.
All righty,
Have a great day.
you too. Bye-bye.
Will you stay on for a second?